Have you ever wondered what really goes on behind the scenes of major legal decisions, especially in other countries? How fundamental principles actually shape justice on the ground?
It's a fascinating area. And Brazil's Supreme Federal Court, the STF, offers a particularly compelling, sometimes surprising look at that.
Absolutely. So today, our deep dive peels back some of those layers of Brazilian criminal jurisprudence. We're looking at how these core justice principles get tested and interpreted in unique ways.
Yeah, understanding the bedrock of a system like Brazil's, it really clarifies how a society prioritizes rights and, defines justice. We're tapping into the highest court's thinking here.
Exactly. Our mission today is basically to unpack key legal principles, drawing directly from the STF's own rulings and interpretations, plus a detailed report on human rights and free speech.
And we'll look at how they're applied through real cases, right,
Yeah.
to see the nuances.
That's the plan. Discover what makes the system robust and, honestly, quite insightful for anyone trying to get a handle on global justice concepts. Sort of a shortcut through the complexities.
Okay, let's dive in then. One of the absolute cornerstones, really, anywhere you look, is due process and ample defense. In Brazil, it's specifically the due process of law, or devido processo legal.
Devido processo legal. Got it.
And it's all about ensuring fundamental fairness, protecting individual liberties, throughout the whole criminal process.
And the STF hasn't just left it as a vague idea, right? They've really spelled out what it means in practice. What are some of those core rights they've highlighted?
Well, for starters, the right to remain silent. The STF is crystal clear. Choosing to stay silent absolutely cannot be used against the accused at all.
That's a huge protection.
It is. It's an ironclad shield against self-incrimination.
What else? I know there was something really striking about unlawful evidence.
Oh, definitely. The absolute prohibition on using illegally obtained evidence. It's non-negotiable. Even if it means, well, losing what seems like the truth in a case.
Even if it means someone might walk free.
Precisely. The STF says this principle trumps any appeals to, say, proportionality based on how bad the crime was. The focus is on deterring state misconduct, ensuring rights aren't trampled.
Wow.
It really underscores that the legitimacy of the process itself is paramount. How evidence is gathered matters immensely.
Okay, so the how is just as important, maybe even more important than the what. What else falls under this devido processo legal umbrella?
It also guarantees the right to be properly and promptly informed of your rights. And, critically, the right to legal representation. That's indispensable, non-negotiable. You must have a lawyer.
Cannot be denied a lawyer.
Correct. And the right to a public and swift trial. No undue delays. There's this balance they emphasize between achieving justice and doing it efficiently.
And I found this fascinating. This isn't just for Brazilians, is it? Even foreigners without official residence get these protections.
That's right. Even non-Brazilian citizens without domicile there are fully entitled to these fundamental due process rights.
What's it tell us?
It really highlights the universality of these rights within their legal system. No arbitrary or discriminatory treatment based on nationality. It's a significant mark of, a mature, rights-focused system.
Okay. Now, closely related is another big one, the presumption of innocence.
Equally critical, yes. Absolutely fundamental.
It sounds simple enough. Innocent until proven guilty. But I gather the STF has explored some, let's say, interesting nuances here.
Well, the core idea is just that. No guilt by mere suspicion. Guilt has to be proven beyond doubt, not just assumed.
Standard stuff.
Standard stuff. But here's where it gets interesting. Some STF rulings say that just being under police investigation or having ongoing criminal cases cannot be used as bad antecedents. Mas on antecedentes is the term to justify a harsher sentence.
So just being investigated doesn't automatically make your record look worse for sentencing purposes.
According to those rulings, no. The reasoning is that only a final, unappealable conviction should overcome the presumption of innocence.
Okay, that makes sense. But you said some rulings.
Exactly, because other rulings do allow police inquiries and ongoing actions to be considered maus antecedentes, provided it's properly justified, arguing it doesn't violate the presumption of non-culpability.
Huh. So there's a bit of a conflict there, or at least different interpretations.
You could say that. It really shows this ongoing judicial wrestling match, doesn't it? How do you balance the right to be presumed innocent against the practical need to assess someone's history when sentencing? It's a dynamic area.
A real tricky balance. It highlights how legal thinking is always evolving. Okay, moving on. Let's talk sentencing principles. There's one called the principle of insignificance, or bagatella.
Ah, yes, Agatella.
It allows minor offenses to be basically dismissed as atypical if the harm is negligible and the act isn't seen as particularly reprehensible. Sounds like common sense for minor stuff.
It is, and some of the examples are quite, well, memorable. They really show how it works. For instance, the case involving flanolinhas, those informal car park attendants.
Right, you see them in cities.
If their actions didn't cause any real harm and weren't highly reproachable, the court deemed it insignificant. It's a way to filter out cases that don't really warrant the full weight of the criminal justice system.
Okay, what else? I remember a stove.
Yeah. The military member who didn't return a stove worth about $455. But crucially, they'd been told to keep it as reimbursement for some improvements they'd made, and the money was later returned anyway.
So, context matters a lot.
Hugely. That was deemed insignificant, too. It shows a really pragmatic approach.
And there was an environmental one, too, wasn't there? With shrimp.
That's right. A fisherman caught with just 12 shrimp in a net, technically violating fishing regulations. But the court called it an insignificant environmental crime because the value was tiny and it posed no real danger to the ecosystem.
So bagatella isn't just about money, it's about the overall impact and social blame.
Precisely. It's a multifaceted assessment.
But it's not a complete free pass, surely. When does insignificance not apply? Seems like it could be misused.
Good question. You're right, it has limits. It can't be applied to theft furto if there was, say, abuse of trust involved, or a violation of privacy, or if a minor was part of it.
Okay, so aggravating factors matter.
Definitely. Also, tax evasion. Just because the amount owed is below the threshold for immediate legal action, like, say, $10,000, doesn't make the crime insignificant. That threshold is just about enforcement priority. It doesn't wipe the slate clean.
Got it. The debt and potential criminal liability still exists.
Exactly. And, very importantly, bagatella doesn't apply if the accused person is, deeply involved in organized crime. This principle is for genuinely minor, isolated acts, not a shield for serious criminals.
Makes sense. It's about separating the truly trivial from things that might look small but are part of a bigger picture. Now, this idea of fairness also shows up in how the law changes over time, right? This novatio legis in melius.
Yes, the retroactivity of a more favorable law. It's a key principle. Basically, if a new law makes a crime less severe or even decriminalizes it altogether, that new, more lenient law can apply backwards, retroactively, to benefit someone accused or convicted of that crime, even if they committed it before the new law existed.
So wait, if a law changes today to reduce the maximum sentence for a crime, someone already serving time under the old, tougher law could actually get their sentence reduced?
Potentially, yes, that's exactly the idea. A good example given was a law that limited how much remitted good time could be revoked from a prisoner. It was capped at 1/3, and this applied even to past offenses.
Interesting.
Or when a new unified classification for qualified robbery turned out to be more favorable in some cases, it shows a commitment to applying the most lenient version of the law, which is quite progressive.
And following that theme, there's the no worse outcome rule, non reformatio in pejus. Sounds like it protects someone who appeals.
It does, specifically the defendant. If only the defense appeals a conviction, the higher court cannot, under any circumstances, increase the sentence or make the defendant's situation worse.
Why is that important?
It's designed to remove the fear factor from appealing. Defendants should feel free to exercise their right to appeal without worrying that they might actually end up in a worse position. It avoids that chilling effect.
So even if the appeals court looks at the case and thinks, this original sentence was actually too light, they can't increase it if only the defense appealed.
Correct. Their hands are tied on increasing the penalty in that scenario.
What if a whole new trial is ordered, maybe by a jury? Could new, worse facts come out then?
Even then, if a new trial happens because of the defense's appeal and maybe new aggravating facts are found, the eventual punishment still cannot exceed the sentence from the original trial, assuming the prosecution hadn't also appealed or that decision was final for them.
That offers a real safety net for the defendant deciding whether to appeal.
A very powerful one. It builds trust in the process.
Okay, let's shift gears slightly. Our sources also touched on some specialized areas. First, content moderation and free speech, particularly online.
Yes. A very hot topic globally.
The report highlighted the challenges, didn't it? Social media platforms, being private companies, trying to regulate public discussion, especially around disinformation in Brazil. What were the key tensions?
Well, it's that classic balancing act, isn't it? Freedom of expression versus the need to combat harmful content like disinformation, which can cause real problems. The source dives into this within Brazil's legal framework, comparing it sometimes to U.S. approaches.
Did it show much impact on U.S. citizens or businesses, though?
Actually, no. The report specifically noted it provides limited direct evidence on that front. It really underscores that these legal battles and the specific challenges around disinformation are being tackled primarily within Brazil's own unique context.
Right. Different countries, different legal and social landscapes online. Now, another really significant area mentioned was the Maria da Penha law, dealing with domestic violence.
Yes, the Lei Maria da Penha. This is far more than just another statute. It's truly landmark legislation in Brazil.
Why is it so significant?
It was specifically created to combat domestic violence against women. And its key impact, one of them anyway, is that it makes even minor physical harm, lesões, corporal leaves, committed against a woman in a domestic setting, a public, unconditional criminal action.
Unconditional.
Yeah.
What does that mean practically? Does it mean the victim can't just drop the charges later?
That's exactly it. Once the authorities are involved, the case proceeds regardless of whether the victim later wants to withdraw the complaint.
Wow, that's a major departure from how things might work elsewhere, or how they used to work.
It is, and it's seen as constitutional, aligning with international treaties. It reflects the state taking a very strong stance, recognizing its duty to protect vulnerable individuals and ensure access to justice. It directly confronts past power imbalances where victims might have felt pressure to retract.
A really powerful statement about protecting vulnerable people. Okay, one last specific area, money laundering.
Right. Critical in tackling organized crime and corruption.
What's the key legal point here, according to the STF's view?
The main thing is its classification as an autonomous crime. This means money laundering is legally separate and distinct from whatever initial crime generated the dirty money, the predicate offense, like corruption, drug trafficking, whatever it was.
It's not just seen as the final step of the first crime.
No, it's not just the exhaustion of the prior crime, as they say. It stands on its own.
So even if proving the original corruption case is, say, incredibly complicated or hits roadblocks,
the money laundering charge can still proceed independently. It's a powerful tool because it allows prosecutors to go after the illicit profits and those handling them, even if the underlying crime is tough to nail down completely. Makes it much harder to enjoy ill-gotten gains.
I see. It gives prosecutors another angle of attack.
Definitely.
Okay, so wrapping up our deep dive today, we've really covered some fascinating ground in Brazilian criminal justice, hopefully giving you a bit of a shortcut to understanding this complex system.
Yeah, we looked at the robust protections under devido processo legal, like the right to silence and the exclusion of illegal evidence.
Right, and those tricky nuances in applying the presumption of innocence, that ongoing judicial interpretation.
And the very practical, sometimes surprising, application of the principle of insignificance, bagatella. Those examples were quite telling.
They really were. We also touched on the protective rules like novatio legis in melius, applying more favorable laws retroactively, and non-reformatio in pejus, ensuring appeals don't backfire on the defendant.
And specific frameworks like the vital Lei Maria da Penha, tackling domestic violence and seeing money laundering as its own distinct crime.
And understanding these principles, I think, gives you a much deeper appreciation for how legal systems everywhere grapple with fairness, accountability, and, well, the complexities of human behavior.
Absolutely. It's a constant balancing act.
So here's something to think about. Considering how these principles we've discussed are applied, especially things like bagatella or the nuances and presumption of innocence, where do you think the line should ideally be drawn between ensuring strict legal rules are followed and allowing room for, practical realities and judicial discretion?